everyone, welcome back to Immigration Dream University. I'm your lawyer attorney Tadisha Rowe here at American Legal Immigration Center located in the DMV in the United States. Thank you guys so much for tuning in to another episode. So today I'm going to bring you guys a question that is quite frequent amongst my clients, and especially those who have been here for X number of years and maybe they have children who've somehow acquired U.S. citizenship status. Maybe they were born here, or maybe they found a way to adjust their status to legal permanent resident and then to a United States citizen, and so they're now at a certain age, which is age 21 or older, where they can possibly apply for that parent to now adjust their status. Now I say possibly because although if you do have a United States citizen child who is 21 years of age or older, it does mean that you are now considered an immediate relative, and yes, that child may petition for you to adjust your status to a lawful permanent resident. However, there are many considerations that you should take into place before you make that decision and before you start walking through the process. So, first of all, again, if you do have a child who is a United States citizen who is 21 years of age, then yes, that child can petition for you to become a lawful permanent resident. The first step that they need to do is to file that I-130 petition, and you can find that by going to uscis.gov. Now, just the fact that you are a parent of that child who is now of age and they are a United States citizen means that that petition itself is going to be approved. Does that mean that you will actually get your green card? No, not necessarily. One of the key things that comes into play at this point is how did you enter the United States? If you entered legally, meaning that you were inspected and paroled into the United States, usually that's through a visa, maybe some other means, at the time that you entered the United States, and perhaps you overstayed or whatever the circumstances are, maybe you haven't overstayed, maybe you're still within that the time frame that you were allotted to be here, but you would like to adjust your status, then you can certainly do that. The adjustment of status itself means that you can change, adjust your status from inside of the United States while you're here, right? But you have to have entered lawfully, meaning that you were inspected and paroled. Now, on the other hand, that means that you have acquired unlawful presence while you are here. And so that means that although that I-130 petition is going to be approved for you, and more than likely you're going to get some kind of notification from the National Visa Center in your country of origin telling you that yes, they have your documents there, USCIS has forwarded it to them, and maybe you think, great, now I can go and pick up my green card and come back into the United States. That is not how it works. If you do not take the additional steps that I'm about to talk about right now, then when you go to get that green card, you're going to find yourself stuck there because there is an immediate bar that comes into place as soon as you exit the United States. And depending on how long you are unlawfully present will determine how long, will determine how long that bar is. So in some cases it might be 3 years, in other cases it might be even up to 10 years. So this is where you want to be very careful. If your I-130 petition is approved, assuming that it is, right, then before you take the next step, if you entered illegally, you would like to get a 601A waiver. The 601A waiver is an application for provisional unlawful presence. Now, you can actually apply for that while you're in the United States, and you should apply for it while you are still in the United States, because once it's approved, then that information is also sent to the consulate in your country of origin. And so at that time, when you go back now to get your green card, to pick it up, to come back into the United States, they will already have that waiver on file showing that, yes, you were in the United States unlawfully present for X number of years, however long it is, anytime over 6 months. However, you have gotten a waiver that says that based on those grounds, you are now eligible to come back into the United States now that that green card is available to you through your qualifying relative, right? Simple enough. However, keep in mind also that your child, so that same child that filed that petition for you as your qualifying relative, cannot file for that 601A waiver. The reason being, a 601A waiver is only applicable for hardship in cases of hardship to your spouse, who is either a legal permanent resident or a United States citizen. So if your child, who's now 21 years of age or older and also a United States citizen, files that petition for you and it is approved, and now you are on step 2 of getting that waiver done. Hardship, or extreme hardship in this case, in order to qualify for that waiver, to that child is not going to allow you to get that waiver, okay? So in cases like that, what you want to do is, if you have a qualifying relative, which is a legal permanent resident, spouse or parent, you can use them in order to file your waiver. But just hardship, extreme hardship to that child alone will not get you approved for that waiver. And so although you will get the approved I-130 petition saying, yes, USCIS recognizes your relationship to your child, that they are a citizen, and that they can petition for you, if you did not enter the United States legally in the first place, it still does not solve all of your problems. So guys, as usual, this is legal information, not advice. There are other circumstances that may come into play, such as if you have any other grounds of inadmissibility. And so for those reasons, I do highly recommend that you speak to an attorney before you attempt any of these steps. And of course, we will be happy to speak with you here. All right, guys, so I hope that this information was helpful to you. And as usual, I'm so grateful and thank you for tuning in to another episode of Immigration Dream University. I do try to post videos on a weekly basis, just bringing you topics that are relevant. Either I'm getting them from my clients or potential clients, or things that are out in the news. And so my goal is to keep you guys as informed as possible. If you did find this information helpful, please do thumbs up. That means that you like this video, and also subscribe, which is that little red button somewhere. You guys know how to do it already, but hitting that subscribe button helps me out a lot. Just so that you guys know, I'm at 41, I believe, at the time that I'm filming this, which in the grand scheme of things may not seem that big, but it is actually a huge deal to me. I've been posting videos consistently for about 2 months now, actually less than 2 months. So that is huge growth, especially when there's so many people that you can tune into. So I really do appreciate each and every one of you supporting my channel. And the goal is to be at 100 by the end of the summer. So if you guys can hit that subscribe button, you are helping me out a lot. All right, guys, so good morning, afternoon, evening, night, whatever it is, wherever you are. And I look forward to seeing you guys again. Good night.